The issue in this case are whether public sector union fees are constitutional. The parties to this case are Mark Janus, child support specialist employed by the state of Illinois, and the American Federation of State, County, and Municipal Employees, Council 31, otherwise known as AFSCME Council 31, as well as various departments of the state of Illinois. AFSCME, its function is to bargain with the state of Illinois over Illinois' policies that affect employees. And the theory of the case basically stated is that it offends the First Amendment to force an employee to support union speech that he or she does not support. To understand the case in Janus, you really have to go through the chronology of the case law dealing with public sector union fees. And that story begins with Abood versus Detroit Board of Education in 1976. The issue in Abood was, could public school teachers be forced to pay union dues as a condition of keeping their jobs? And what the Supreme Court said is partially yes and partially no. The court said that public employees can be forced to pay for the union's costs of collectively bargaining with the government and for enforcing the resulting contract. However, the court held it was unconstitutional to force employees to pay for what it called political and ideological expenses. Now, the dissenting justices at that time criticized that distinction by saying it doesn't exist because collective bargaining in the public sector is political. You're bargaining with the government to adopt a policy. That's a political activity and therefore should be just as non-chargeable to non-members as other political activities. However, the Abood dichotomy was the law and remains the law to this day. Then in 2014, another case came to the Supreme Court called Harris versus QUINN. Harris versus QUINN concerned whether, under Abood, individuals who were not public employees could be forced to pay compulsory union fees. And so the question in Harris was, is that constitutional? And the court held that it wasn't, that Abood did not extend outside of the employment context. But for our purposes of this conversation, more importantly, the Harris court strongly criticized Abood. The following year, the Supreme Court took another case that directly challenged Abood. This case was called FRIEDRICHS versus California Teachers Association. And the issue in FRIEDRICHS was the exact same issue as in Abood. Could you force public school teachers to pay compulsory union dues to keep their jobs? However, 1 month after oral argument, Justice Scalia unexpectedly passed away, deadlocking the court at 4-4. As a result of that, the court split 4-4 in FRIEDRICHS and dismissed the case on the grounds that it couldn't reach a decision, leaving the issue unresolved. The primary arguments that Mr. Janus is making in this case is that there is no distinction between a political activity and collective bargaining in the public sector. In the case of the public sector, you're talking about speech directed to the government to impact governmental policies. And so that brings up speech at the core of the First Amendment, namely speech to influence public affairs. In the meaning of the First Amendment, that's called petitioning. Another word more commonly used is lobbying. In other words, bargaining with the government is political. And if bargaining with the government is in fact a political activity indistinguishable from lobbying, it should be unconstitutional under the First Amendment to force Mr. Janus and other employees to pay for that activity. So the union's principal argument in this case is that because all employees receive the union's services and benefit from the union's representation, all employees should have to pay for that service. Another argument that AFSCME makes in this case is that the government has greater leeway in dealing with employees than it does with citizens. So even if the government could not enforce a citizen, for example, a man on the street, to support union advocacy, when the government is acting as an employer, its power over the employee is greater in a constitutional sense. So if the unions prevail in Janus, the law will stay as it has been since 1977. Public employees will continue to be forced to pay compulsory union fees in all non-right-to-work states, which can range anywhere from 60 to 90% full union dues. If the court holds in Mr. Janus's favor, public sector union fees will become unconstitutional, which means that under the First Amendment, no public employee can be forced to pay dues to a union advocate against their will.